Good afternoon, everyone. Welcome to today's special magistrate hearings. We're going to have two matters on the agenda today. The first is a variance application. The second is a code enforcement issue. The variance is for VAR 2023-02 at 215 Boardwalk Place East. The code enforcement case is case number 2023.3600, and that property is at 414 140th Avenue East. There were two other code enforcement cases that were on the agenda that have been dropped. So if you're here on those other code enforcement cases, they are not going forward this week. You can follow up with the city after the meeting. So only be two matters, and the first will be the variance. So with that, welcome to the City of Madeira Beach variance/special exception, special use, special magistrate hearing. My name is Bart Valdez, and I am the appointed special magistrate to hear today's cases. I'm a practicing attorney and have been a member of the Florida Bar for over 20 years. I've been appointed to this position in accordance and with the authority set forth under Florida law and the City of Madeira Beach Code of Ordinances. It is my role to fairly and objectively review the matters presented today in these variance requests. As such, I would like to advise you of certain matters related to today's proceedings. Today's matters will be heard in the order that they appear on the agenda. At this time, I have read and reviewed the applications with all attachments, any written submissions by anyone having an interest, any timely submitted written objections, and the materials provided by the city staff. In all cases, the hearing will be conducted in the following order. We'll confirm that public notice has been proper. The city will present its case and staff report, and the applicant may ask questions of the city's representative. The applicant will present his or her case supported by witnesses and evidence, and the city may cross-examine each witness. Then we'll have public comment. Public comment will only be solicited or received from parties directly affected by the variance. Individuals testifying do not have the right to cross-examine the parties. All public comment shall be limited to 3 minutes per person unless waived by the parties. Public participation will then be closed, and I will deliberate and make a decision to grant or deny each variance requested in the application. Formal rules of evidence do not apply to this proceeding. However, I will exert every effort to ensure that fundamental fairness is afforded to all parties. After my decision today, I will issue an order. The order will be reduced to writing, and you will be provided with a copy by mail. Therefore, please make sure that we have your current address. Additionally, you are advised that I do not have the authority to grant you a building permit. You must still obtain a building permit for any work you intend to do on your property. If you wish to present any information to me today, it is necessary that you swear or affirm that you will tell the truth. Therefore, in just a moment, the city attorney will administer the oath and swear in any witnesses. If anyone expects to talk to me today during the hearing, then you will need to rise and be sworn. This includes any members of the public who are directly affected by the variance and may wish to provide public comment. Mr. Trask, can you please go ahead and administer the oath?
Sure. Anyone that's going to speak, if you could stand up, raise your right hand, I'm going to swear you an oath. Anyone that's going to speak? You swear that the testimony you're going to give today is going to be the truth, the whole truth, and nothing but the truth? Yes. Thank you very much.
All right, the first case on the agenda is VAR 2023-02 for the property located at 215 Boardwalk Place East. Is the city ready to proceed?
We are.
Go ahead, Mr. Trask.
City would call Marcy Forbes. Marcy, what is your job responsibilities here at the City of Madeira Beach?
I'm the Community Development Engineer.
Okay, and how long have you been in that position?
I was hired May 15th of 2023. Prior to that, I was a subconsultant to the city for a couple of years.
Okay, and when you were a subconsultant with the city for a couple of years, what engineering firm was that through?
Doolin Associates in the beginning, and then they were acquired by Trans Systems.
Okay, and how long were you with Doolin Associates then?
A little over 2 years.
Okay, thank you. All right, do you have, are you going to be the one presenting this case then?
Yes.
Okay, I want you to go ahead then and present it, and then afterwards we'll submit your report into evidence.
Okay, sounds good.
Okay.
So this variance is a request from the coastal AE 11 flood zone, base flood elevation BFE plus 1 foot freeboard, requesting a 3-foot variance from the 15-foot design flood elevation to a 12-foot design flood elevation. This is in accordance with specification code provisions, section 94-75, considerations for issuance of a variances, Section 94-76, conditions for issuance of variances. The background. Variance 2023-02 for 215 Boardwalk Place East would allow for the construction of a commercial structure to be built that would have level access with the structure to the Johns Pass Boardwalk. In the Madeira Beach Code of Ordinance, Section 14-39, Technical Amendments B requires, 1, all buildings and structures erected within coastal high-hazard areas and coastal A zones shall be elevated so that all the bottom of the lowest horizontal structural members supporting the lowest floor, with the exception of pilings, pile caps, columns, grade beams, and bracing, is elevated to or above the base flood elevation plus 4 feet of the design flood elevation, whichever is higher. The Code of Ordinance Division 7, 94-75 and 94-76 allows for a variance to floodplain requirements from Madeira Beach ordinances, which currently has a 4-foot freeboard, but in no circumstances relief from the Florida Building Code requirements, which currently has a 1-foot freeboard. As with all other businesses along the boardwalk, the structure would not attach to the boardwalk, but instead would be constructed adjacent to the boardwalk and provide direct access to the boardwalk via a quote-unquote level walkout. This access point would be ADA compliant and provide ADA access that is not currently available along the easternmost end of the boardwalk. A floodplain variance request for relief from the current 4-foot freeboard must meet the criteria for variances while still being compliant with all other construction requirements, meeting the City of Madeira Beach land development regulations, FEMA requirements, and the Florida Building Code. Part 2, variance criteria and analysis. Section 94-75, considerations for issuance of a variance. In reviewing requests for variances, the special magistrate shall consider all technical evaluations, all relevant factors, and all other applicable provisions of the Florida Building Code. This chapter and the following. Number 1, the danger that materials and debris may be swept onto other lands resulting in further injury or damage. Our finding. The building will be constructed in accordance with the current Florida Building Codes, meeting all requirements for structures located in a coastal A zone, including but not limited to deep foundation installations, stringent connection points and fasteners, and structural designs such that extreme lateral loads are considered. As such, there is limited danger associated with loose materials or building debris. Number 2, the danger of life and property due to flooding or erosion damage. In addition to the findings stated above, from number 1, deep foundation design considers scouring caused from erosion around pile foundations during storm events, and as such is inherent to the design. In addition, all components constructed below the DFE will be dry flood-proofed, and a certification as to that fact will be provided by the designer. Therefore, there is no anticipated increase in danger to the building occupants surrounding structures due to flooding or erosion. Number 3, the susceptibility of the proposed development, including contents, to flood damage and the effect of such damage on current and future owners. Findings. In addition to all of the findings previously stated in 1 and 2, the building below DFE will be dry flood-proofed, and any non-structural components will be designed to either resist shifting and flotation or to be removed from the site during an approaching storm. The anticipated design and construction techniques will be such that the building will not negatively impact current or future owners. Criteria 4. The importance of the services provided by the proposed development to the community. Findings. The proposed restaurant will improve upon what is currently located on this parcel and provide another route for ADA accessibility via the restaurant elevator. Promoting business redevelopment in this area while maintaining the unique characteristics of Johns Pass Village is critical given all the all the buildings require access to the boardwalk as a fixed point, providing pedestrian traffic to their businesses. Number 5. The availability of alternative locations for the proposed development that are subject to lower risk of flooding or erosion. Findings. The location of the site is unique and offers an opportunity to provide new construction along the boardwalk and improve on what is currently constructed on the parcel. Another location would not provide the same opportunity as the one here. Number 6. The compatibility of the proposed development with existing and anticipated development. Findings. The proposed development is compatible with both current uses and anticipated future use of all businesses along the boardwalk. Criteria 7, the relationship of the proposed development to the comprehensive plan and floodplain management program for the area. Findings. Madeira Beach Comprehensive Plan Policy 4.1.9.6 and Policy 4.1.9.8 reference the importance of Johns Pass Village for tourism and commerce, and that redevelopment needs to fit within the overall theme of the area. The proposed development would align with the redevelopment policies for Johns Pass Village and the Madeira Beach Comprehensive Plan and fit within the established theme of the area. As stated previously, the proposed development would be more resilient compared to the existing structure on the property. Number 8, the safety of access to the property in times of flooding for ordinary and emergency vehicles. Findings. The structure will be accessed in the same manner as other businesses along the corridor via the one-way Boardwalk Place East. Criteria number 9, the expected heights, velocity, duration, rate of rise, and debris and sediment transport of the floodwaters and the effects of wave action, if applicable, expected at the site. The property is in the AE11 Coastal A findings. The property is in the AE11 Coastal A high hazard area and has been mapped as such to take into account expected heights, velocity, duration, etc. associated with storm events. This structure will be built to a higher standards than the surrounding buildings, which are much older and were constructed under different building requirements. All necessary studies and reports utilized in the final design of the building will be reviewed by city staff to ensure impacts from all storm effects have been considered. Criteria number 10, the cost of providing governmental services, criteria 10, the cost of providing governmental services during and after flood conditions, including maintenance and repair of public utilities and facilities such as sewer, gas, electrical, and water systems, streets, and bridges. Finding, there is no additional anticipated hardship associated with the proposed restaurant, given the current parcel usage and in consideration that all utilities will be replaced with current code-compliant construction techniques. Okay, Section 94-76, conditions for issuance of variances. Variance shall be issued only upon 1, submission by the applicant of a showing of good and sufficient cause that the unique characteristics of the size, configuration, or topography of the site limit compliance with any provisions of this chapter or the required elevation standards. Findings. The applicant has submitted sufficient information showing the unique challenges of the site as related to the necessity of accessing the fixed elevation of the boardwalk as compared to the elevation of the business level. 2, determination by this special magistrate that failure to grant the variance would result in exceptional hardship due to the physical characteristic of the land that render the lot undevelopable. Increased costs to satisfy the requirements or inconvenience do not constitute hardship. B, the granting of a variance will not result in increased flooding heights, additional threats to public safety, extraordinary public expense, nor create nuisance caused by on or victimization of the public or conflict with existing local laws and chapters. And C, the variance is the minimum necessary considering the flood hazard area to afford relief. Findings. Granting this variance will not result in any negative impact to the property or adjacent properties and will instead help to further options for more resilient construction in Johns Pass Village while maintaining the unique boardwalk, pedestrian-friendly build-out that currently exists. The designer has spent considerable time reviewing options for meeting FEMA criteria while maintaining access to the boardwalk and has determined this is the option of least variance that will still allow boardwalk access. Number 3, receipt of a signed statement by the applicant that the variance, if granted, shall be recorded in the office of the clerk of the court in such a manner that it appears to be in the chain of title of the affected parcel of land. Finding, the applicant is aware of and has acknowledged intent to comply with this requirement. Number 4, if the request is for a variance to allow construction of the lowest floor of a new building or substantial improvement of a building below the required elevation, a copy in the record of a written notice from floodplain administrator to the applicant for the variance, specifying the variance between the base flood elevation and the proposed elevation of the lowest floor, stating that the cost of federal flood insurance will be commensurate with the increased risk resulting from the reduced floor elevation, up to amounts as high as $25,000 for 100 of insurance coverage. $25 for 100 of insured coverage, and stating that the construction below the base flood elevation increases risk to life and property. Finding, the applicant is not requesting to build below the required BFE, but is instead requesting relief from the additional requirement of the 4-foot of freeboard, which is unique to the Madeira Beach LDR. The FBC requires, the Florida Building Code requires 1 foot of freeboard, which the applicant will adhere to. Staff recommendations, staff recommends the approval of variance 2023-02.
Thanks, Marcy. I'd like to go through the remainder of the packet that we have. We've gone through the staff report up through page number 7 in the packet. If you could turn to page 8 and follow through to the end of that particular packet, which ends on page 29, and explain to us what these pages reflect.
Just to kind of summarize.
Yeah.
Okay, excellent. Okay. So starting with page 8, this is basically the information provided to us in the application package that identifies the applicant and the property owner, gives a legal description of the property as well as the address, the zoning district, and some other information related to the the base flood elevation location. Going to page 9, this is the owner certification, which has been executed on June 22nd of 2023. Page 10 is what the architectural firm has provided to kind of explain, to capture what was in the staff report and to answer some of those questions. So they addressed this to the special magistrate, and they've provided exhibits as well that have been listed here. So one by one, they've gone through to meet the criteria of the Madeira Beach Land Development Regulations for submitting a variance. And they've done that from pages 8, not 8, starting with 10, 11, 12, 13, and then 14. So they've gone through and addressed all the items that we requested or that are requested. They also provided some exhibits showing the elevation of the building. Obviously, this is just kind of a proposed theme of what the building will look like and the elevations of which it'll be connecting or how they'll be accessing the boardwalk. They provided the exhibit to show what their variance would look like and what it would look like if they didn't get it. So they've provided like 2 exhibits showing those. They've also provided a survey of the location.
I want to stop you right there. So looking at the survey of the location, which is page 18, can you explain to the special magistrate where the property is on this schematic?
Let's see. Give me 1 second. Boardwalk Place East. So if you're looking at it and you're reading it right side up so that you can read Boardwalk Place, it's there towards the far right side.
Okay, and if you can give some,
Let's
points on that survey as a starting and ending. I understand what you're saying. It would
Right.
be south of Boardwalk Place East,
Yep. So
the
they've
far right corner of the document,
Correct.
that odd-shaped property, correct?
Correct, and it is labeled, the parcel number is correspondingly labeled on there as the 15-31-15-00000-410-02000. That is the parcel in question.
Okay.
Sorry about that.
And if you could then go on with the rest of the documents in the packet, starting at page 19, what are these documents?
Okay, so starting at page 19, we did the public notice. So we, as required, we mailed out notices to people within 300 feet of the property, and we posted it as well. So this is the information that we gave to the public as required per our LDR.
And that would be on page 19 and 20?
Yes, sir.
Okay. What is page 21?
21 is the opportunity, notice of intent for an affected party to speak at today's variance if they wanted to.
Did anybody fill out one of these forms and submit it to the city?
No, we did not receive any.
Okay. And page 22?
That begins our affidavit of mailing. So that's our affidavit of mailing. And then,
What does that mean, affidavit of mailing? What was done with that?
I'll have to add, do you want to speak to how?
No, I need to finish your testimony. If you don't know, we'll go back to Mr.
Okay.
Morris first.
Yeah, I
Okay.
apologize, yes, so.
Okay. So it's titled at the top, affidavit of mailing. We'll come back to that with Mr. Morris.
Okay, thank you.
And then the next couple of pages?
So in that, I believe, is just the property appraiser identifying the parcel by which we did the radius for the 300 feet.
That's on page 23?
Page 23, yes.
Okay.
And then page 24 represents the recipients of the affidavit of mailing.
As well as page 25?
Yes, sir.
Okay, and then what does page 26 reflect?
26, we're just showing proof of the posting related to this variance
Was
at the
this-
property.
Okay, that's what I was, so this is a photograph of the notice of public hearing that was actually posted at the property that we're talking about today.
Yes, sir.
Okay, and then the rest of the pages?
So we have a copy of the posting as well at City Hall.
That's page 27?
Page 27, yes. Page 28 is a posting of it at the Gulf Beaches Public Library.
Okay,
And page 29 is where Andrew is attesting to the fact that he posted those at all three of those locations previously identified. That's page 29.
okay.
And as we go to page 30, this is a printout from the property appraiser's website.
That's the code enforcement case, that's the
Oh,
next
sorry.
one. So we don't need to go there.
I retract number, page 30 then.
So we'll stop at 29?
Sounds good.
Okay. So staff recommendation is approval after receiving the application. In addition to that, going through each one of the findings, staff is recommending approval, correct?
That is correct.
Okay. I have no other questions for Ms. Forbes. I know that Mr. Brainerd's in the office, in the building rather. He may have questions.
All righty. Who is going to represent the applicant for purpose of cross-examining this witness? All right, sir, what is your full name?
My name's Scott Brainerd. My address is 101 150th Avenue, Madeira Beach. I am employed by the applicant, and I'm an attorney. And we don't have any questions for,
You knew what I was going to ask, Mr. Brainerd, so thank you. All right, the city want to call its next witness?
We call Mr. Morris for a limited purpose of telling us what that affidavit of mailing is. So, Mr. Morris, what is your job responsibility here at the City of Madeira Beach?
I'm the long-range planner in the Community Development Department.
Okay, and how long have you held that position?
I recently changed that position, but I've been working for the city since 2019.
And what was your position prior to your current position?
Planner and GIS technician.
Okay, are you familiar with item number 22 in the packet called an affidavit of mailing?
I am.
Okay, can you explain to the special magistrate what that affidavit of mailing is for?
It's a proof we did the mailing that day, and we have it notarized to show that we did it within the 300 feet on that day within the required mailing period.
So all the people that were listed on pages 24 and 25 received the notice, public notice by way of mailing?
Correct, and a notice of intent form.
Okay, all right, thank you. I have no other questions of Mr. Morris.
All right, Mr. Trask, I think you've now gone through everything in the agenda packet. Do you want to move pages 1 through 29 into evidence as Exhibit 1?
3 through 29
I'm sorry, 3 through 29, okay?
would move into evidence. Pages 1 and 2 are the agenda, so if there are no objections, Mr. Brainerd.
All right. Mr. Brainerd, do you have any questions for Mr. Morris? All right, let the record reflect that Mr. Brainerd said no, he does not have any questions for Mr. Morris. Does the city have anyone else the city would like to call?
No, sir.
All right. Mr. Brainerd, are you going to be presenting your case on behalf of the applicant or someone else?
we have the architects here who will discuss this.
Okay, great. Come on forward, sir, and give me your full name.
Good afternoon. My name is Dennis Lang. I'm an architect. I live at 2034th Avenue North in St. Petersburg, and I'm the architect working with the applicant for this project. In line with what Ms. Forbes has presented to you, we did make this request for a reduction from the freeboard height from the requested 4 foot that the city requires to the building code mandated single foot to provide us with that 12-foot DFE that we're requesting here. In line with that, we did print out the graphics. I think this really just kind of sums up what we're requesting in terms of a very clear-cut way for us all to understand it. The red line demonstrates the existing boardwalk and its configuration at its far east end, and the profile that we're requesting is represented here in alignment with our proposed future.
I'm sorry, I can't see that exhibit. If you're pointing to it, can you move it forward just a little bit, whatever you're pointing to?
And is this
Thank
the
you.
same, this just a blow-up of what's in the agenda packet? Okay, great.
Okay.
Okay, so, you see? So what we're looking at is the red line of the existing boardwalk with the proposed structure that we're showing beyond in line with our request for that 12-foot DFE for our alignment at level of boardwalk into our first level of establishment, which is in line with building code and with our request. The second graphic that we provided here is actually the two secondary graphics just put on a single board for clarity. You can see here on the one side, this is what we're requesting, is the configuration allowing for the first floor accessible in line with the existing boardwalk permitting the ADA accesses were requested. And this would be in failure to secure the permissions requested. The disparity between the boardwalk elevation and our first floor would create a real technical problem for access from the boardwalk that we're looking to solve now, and as well as give guidance for future opportunities for redevelopment along the boardwalk that we can maintain access.
All right, Mr. Slang, right? Is that-
Lang, L-A-N-G.
Okay. Mr. Lang, is there anything else you want to tell me at this point?
No, sir, I believe that Ms. Forbes has done an accurate representation of what our request is for today.
Mr. Trask, do you have any questions for this witness?
No questions.
All right. Thank you, sir. Is there anyone else, Mr. Brand, you'd like to call on behalf of the applicant? All right. Let the record reflect that Mr. Brandon said that no, he does not intend to call anyone else. Okay, we are now at the portion of the hearing where if there are any members of the public who would like to provide public comment, please come forward now and you'll have 3 minutes. Good afternoon, sir. What is
afternoon.
your full name?
Gaetano Critelli.
Can you spell your last name for me, sir?
Crittelli. And I own property on 207 Boardwalk Place. I'm right next door. And for words to please give the okay today to this gentleman to get the approval, because this property be empty for so long. They changed hands about 4 times of our ownership that they want to build something and they never did. Unless these people, they want to get something done and something built. And I give all the support and everything they have, more to it. And I'm very happy that they're building it. Actually, if they need any help, I would like to help them too. Thank you.
Thank you, sir. All right, are there any other members of the public that would like to provide comment on this variance? Come on forward.
Stephanie Berry, a property owner, 205 Boardwalk Place East, right down the street as well. I'm, of course, in agreement with it as well. I think John's Pass has grown exponentially over the course of the last 10, 15 years, and we just need more places for people to join and be a part of, and it looks great, and it's great to see something at that end of the boardwalk for us.
Thank you for your comments. Anyone else from the public that would like to comment on variance 2023-02 for 215 Boardwalk Place East? All right, seeing none, we'll go ahead and close public comment. Mr. Trask, is there anything else?
No, there's nothing else. Staff is recommending approval.
All right, and I did not see any conditions, correct?
That is correct.
All right, based upon the testimony of the city's witnesses and the evidence submitted by the city, as well as the testimony of the applicant's expert witness and the favorable public comments, I'll go ahead and grant the variance. That will conclude the hearing on VAR 2023-02. You guys can go ahead, and if you don't want to stick around, you can head out.
Thank you all very much.
All right, welcome to the City of Madeira Beach Code Enforcement Hearing. Once again, my name is Bart Valdez, and I am the appointed special magistrate to hear today's cases. I'm a practicing attorney and have been a member of the Florida Bar for over 20 years. I've been appointed to this position in accordance and with the authority set forth in Chapter 162 Florida statutes. It is my role to fairly and objectively review the matters presented. As such, I would like to advise you of certain matters related to today's proceedings. Today's matters will be heard in the order that they appear on the agenda. Every effort will be made to hear all persons having relevant evidence, argument, or comments to offer related to the specific case that is being heard. If you wish to speak today, it is necessary that you be sworn in by the city attorney. If you are already sworn in, you do not need to be sworn again, but if you have come into the hearing since we started, you will need to be sworn. In all cases, since the city has the burden of proof, the city will present its case first. The respondent or property owners will then be given the opportunity to refute the city's allegations. Formal rules of evidence do not apply to this proceeding. However, I will exert every effort to ensure that fundamental fairness is afforded to all parties. After hearing all relevant evidence, I will issue an order. The order will be reduced to writing, and you'll be provided with a copy by mail. Therefore, please make sure that we have your current address. Additionally, you are advised that I do not have the authority to grant you a variance, permit, or special exception of any kind during this hearing. My role is solely to determine whether a city code has been violated and to provide you a reasonable time to correct the violation by whatever means is available to you. Please be advised that you may be subject to a fine and a lien may be recorded on your property if the violation is not corrected by the compliance deadline. If you wish to present any testimony or information to me today, it is necessary that you swear or affirm that you will tell the truth. Therefore, at this time, if there's anyone else who would like to present anything to me today and you have not already been sworn, please rise and be sworn. All right, seeing nobody, we'll go ahead and call the first and only case on the agenda today, which is case number 2023.3600 for the property located at 414 140th Avenue East. Is the city ready to proceed?
We are.
Go ahead, Mr. Trask.
The city would call Grace Mills. Grace, if you could explain to the special magistrate your position here at the firm, at the city of Madeira Beach, and also your job responsibilities.
Yes, my name is Grace Mills. I'm the code enforcement officer for Madeira Beach, and one of the responsibilities of my job is issuing code violations.
And how long have you been in this position?
6 months.
Okay. Are you familiar with this property at 414 140th Avenue East here in Madeira Beach?
I am.
Okay. Is this a proactive case or was it complaint-driven?
It was complaint.
Okay, and what was the complaint that the city received?
I believe it was from a previous tenant that's no longer at the property, and complaints of violations on the bottom level of the apartment.
Okay, so once you received the complaint, did you go out to the property to determine whether or not that there were any violations at the property?
Yes, the tenants finally scheduled a appointment with us and let us into the property, and that's when we discovered the violations.
Who was the name of the individual that gave you consent to enter the property?
Dan Gavir, I believe.
Okay, can you spell the last name for us?
I believe it's Gavere, if I'm not mistaken.
Okay. And what was the date that you went out to the property?
Let me look for this. It was April 25th of 2023.
Okay. When you go out to the property, did you find that there was a violation that existed?
Yes, the building official did.
Okay. So let's back up just a little bit. I want to establish who the owner of the property is. Who is the owner of the property and how do you know?
The owners of the property are Mercedes Santos and Teresa Volt, I believe, is how you pronounce it. And if you see on the screen, there's the Pinellas County Property Appraiser card that lists them as the owners.
Okay, that's also pages 30, 31, and 32 of the packet?
That's correct.
Okay. So did you also confirm the ownership through the tax collector's office?
I did. That's going to be the following pages of 33 and 34.
And did it also reflect the same owners?
Yes.
Okay. Once you've determined who the owners were and that there was a violation at the property, did you issue a courtesy notice of code violation to the property owners?
I did, yes. And that is reflected on page 36 to 30, or excuse me, 35 to 37.
All right. So when you issued this courtesy notice of code violation, what was the date that it was sent?
April 26th of 2023.
And what were the code violations that were being cited?
Section 8652 when required for a failure to obtain a building permit for the build-out. And there was also a section 110, 177 for permitted uses in the R1 district, which we're not pursuing.
Okay. But at the time you issued the courtesy notice of code violation, can you tell me why it was included in the notice?
I believe at that time there were tenants living in the bottom of the property.
Okay. So can you explain why that would be a violation of the code?
For District R1, it is single-family dwellings and public education facilities only allowed, and rentals are not allowed for that zone.
So you cannot have two families living on the same property in two different units?
Correct.
Okay. All right. When you issued this courtesy notice, did you tell the property owners the date that you were going to follow up to make sure that they were in compliance?
Yes, on the bottom of page 36, there's a follow-up date of May 10th, 2023.
And did the letter tell them what type of corrective action they needed to take to bring the property into compliance?
Yes, it stated either the property owner and/or a licensed contractor will need to apply and obtain an after-the-fact building permit to comply. If it cannot be obtained, the unpermitted work must be removed.
Did you get a response from the property owners to this letter, this courtesy letter?
Let me look for my paper. I don't believe I have a response for this certain letter and email, but there was a phone call to talk about the violations and what would need to be done moving forward.
Okay, and when, first of all, who made that phone call? And did you receive that phone call, or was someone else in the city?
I received the phone call, and I believe it was Teresa, one of the property owners.
Okay, and what was the question, and what was the discussion about?
About the violation letter and what can be done to bring the property into compliance. It had been relayed that there was a certificate of occupancy through the county, which I had not seen on the county's website, so I had asked for copies so that my building official and I could talk about them and see what would be the best way to move forward to bring the property into compliance, and those were never shared.
Okay. So how did the conversation end then?
That I would follow up with our building official and the building department and planning and zoning to see what would be the best way to move forward.
Okay, and did you do that?
Yes, I notified them, and they decided to put letters together on what their best actions would be.
Okay. I wanted you to turn to page 37 in the packet. It's the unsafe building placard. Was that something that you issued or someone else in the city issued?
No, our building official, Frank DeSantis, issued that.
And that was issued on the day that you did the inspection?
That he did the inspection, correct.
Okay. All right. Now I'd like you to turn to page 38 of the packet, the notice of code violation. This is a notice of code violation that you issued on behalf of the city?
Correct.
Okay. And what was the date of that notice of code violation?
That is May 10th, 2023.
Okay. And what was the reason that this notice was sent?
We do a courtesy letter of violation first, and then if we do not get a response or the violation cleared in that time frame, written on the bottom of the first letter, we send a actual violation letter out.
And that's what this is?
Correct.
And it basically is citing the two same code sections, failure to get a building permit under section 8652 and also violation of section 110-177.
Correct.
Is that correct? Okay. And did you also attach to it the copy of the unsafe building placard?
Yes, that was involved as well.
So that's on page 40 of the packet?
Correct.
Okay. All right. When the notice of code violation went out, was it sent by regular mail?
It was sent regular and certified.
Okay. And when you sent it by certified mail, did you get the green card back?
We did not. The owners of the property have relayed that they have issues getting certified mail delivered to their property, which they have let me know. So we actually, if you look at page 41, that's a copy of it going out. And we did not get it returned.
Okay, did the regular mail come back to the city?
It did not.
Can you explain what pages 42 and 43 are?
Yes, that is the building and planning and zoning recommendation letter, kind of a rough draft that we sent to the homeowners of what they would need to do to bring the property back into compliance.
And when was this sent to the property owners? Was that attached to the notice of code violation?
No, that was sent in an email.
Okay. And when would that have been done in relation to the other letters?
This was sent after the notice of code violation. I know the planning and zoning and the building departments had to work on these together, so this was sent, I don't know an exact date,
Okay.
but it was after the notice of violation.
But there was a letter that eventually went out that had the same information, correct?
Correct. That's on page 44, 45, and 46 is the letterhead. That was the final letter. That was sent June 28th, 2023.
And what was the purpose of this letter?
This was to actually be put on letterhead and signed from our city manager, Robin Gomez.
Okay, and was this also sent by regular mail?
Yes, it was actually sent certified mail, which is on page 47.
But was it sent regular mail as well?
It was, yes.
Okay. And was the green card signed for and sent back to the city?
It was not. On page 49, it's reflected for certified mail, return to sender, no such street.
But the regular mail did not come back to the city?
It did not.
Okay. All right. And if we could turn to page 50 in the packet, if you could explain what that is.
Page 50 is a double posting of the unsafe that was posted to the original back door of the property, which is on the gate to face the street. We had got a complaint from the previous tenant stating that you weren't able to see the violation from the street, which it needs to be visible from the street, so we posted that there as well.
So the unsafe structure placard, that's only with regard to the first floor, correct?
Correct.
So they could still live on the second and third floor if there were other floors, correct?
Correct.
Okay. And then page 51, can you explain that, what that photograph is?
Pages 50 and 51 are just photos from the file, so it's another copy of the unsafe that was originally posted.
Okay, and what is in the packet, it just looks like a blue piece of paper. Can you explain what that is?
I will show you that one. That's just a bigger blown-up photo of where it's posted on the gate.
Okay. After the notice of code violation letter went out, and then the second letter went out from the city manager, did you receive any response from the property owners?
We had received a few responses through email that they had received, because once I knew that they had issues receiving certified mail, I also sent copies of them to Teresa's email, which I had communication with, and we have a few received emails from where they got them.
Okay. Did at any point, did they tell you that they were going to bring the property into compliance?
Not that I'm aware of, no.
Did they at any point admit to you that there was a violation of either one of those two code sections?
I don't think there was an admission that I'm aware of.
Okay. So did you set the matter for hearing, for today's hearing, and send out a notice of hearing for today?
We did, yes.
Okay. If you could turn to page 53 of the packet. Is this the notice of hearing that was sent out?
That is, yes.
And when was it sent out?
July 21st, 2023.
Okay. And does it specifically reference the fact that there is going to be a hearing today in this location at 2 p.m.?
It does, yes.
All right. So that's pages 53 through 55.
Correct.
Was that sent by regular mail?
That was sent regular mail, certified, and posted at the property.
Okay. And was there an affidavit of service then that was issued for the posting of the property?
Yes, that's 56 to 57, which was regular mail, certified mail, and posted at the property.
Okay. And when it's posted on the property, can you explain how that's done?
Yes, I believe I have a photo attached. I'll scroll down to it. Here is our posting on the property. You can see the home in the exterior of the photo, and it is posted with all copies onto the actual parcel.
Okay. And if you could turn to page 63 and 64 of the packet, if you could explain what those are.
Those are copies of the certified mail of where all the affidavits for this hearing were sent certified.
And the notice of hearing?
Yes.
Okay. So the violation that the city is moving forward on is a single violation, correct?
Correct.
And that is that section 86-52, failure to have a building permit for the work that was done for the build-out downstairs.
Correct.
Okay. All right. At this point, I'd like to tender into evidence packet pages 30 through 64, but I do have another witness, but I'd like to move these into evidence.
All right, we'll go ahead and I will accept into evidence as exhibit number 1 agenda pages 30 through 64.
Any objection, sir? No objection. Thank you.
Okay. Mr. Trask, is there anything else you have from Ms. Mills?
Not at this point.
All right. Who is going to be representing the property owner respondents?
Thank you, Mr. Valdez. May it please the magistrate, Wesley M. Conklin. I'm an attorney licensed to practice law since 1977, so I think I'm 45 years in practice. And I'll be representing Ms. Volpe and Ms. Santos.
Excellent.
And I would like to cross-examine if I may.
That's, I was just going to tell you, Mr. Clunkin, you've probably done this before, but this is your opportunity to cross-examine this witness. I'll give you the opportunity to cross-examine the next, and then, of course, I'm going to give you the opportunity to present your case in full and call any witnesses you want as well. So
Thank you.
please go ahead and go forward with your cross-examination.
Thank you. Ms. Mills, would you look again at the notice of hearing, please?
Here.
What address is noted on the notice of hearing?
1745 Wesley Avenue, Evanston, Illinois, 60201-3518.
Oh, I'm sorry, I meant where it has regarding property.
It does show 141, 140th.
That's not the property, is it?
It is not.
For the magistrate's purpose, today's hearing is for a property which is not owned by Ms. Volpe and Ms. Santos. And I object. Ms. Mills, also, you've worked for the city for, I think you said 6 months?
Correct.
All right, and the violation that was noted, section 86-52, when was that adopted by the city?
I'm not aware of that.
Okay. And the city is not pursuing the section 110-117 violation, alleged violation?
That's correct.
Okay. At the time, you did not personally inspect the property, is that correct?
That's correct.
All right. Do you know and since hearsay is permitted at an administrative hearing, if there's other collaborative evidence to support it, do you know if the building inspector found anybody in occupation of floors 2 and 3?
I'm not aware.
Okay. Do you know when the improvement to the ground floor or first floor was made?
I'm not aware.
Do you know who made the improvements?
I'm not aware.
Are you aware of the fact that this property was previously cited for a code violation in September of 2013?
I'm not aware.
All right. In reviewing the city's records, do you know whether any prior violation regarding the first floor was ever acted upon by the city?
From my time frame of being here, I'm not aware.
All right. I have no further questions.
All righty. Mr. Trask, anything else with this witness?
No to redirect.
All right. You want to go ahead and call the next witness?
Yes, I would call Frank DeSantis, the building official. Mr. DeSantis, how long have you been the building official for the city of Madeira Beach?
Excuse me, 9 years. I'm on my 10th year.
Okay. Are you familiar with this property, 414 140th Avenue East?
Yes,
Okay. Did you do an inspection of this property?
yes.
On what date did you do your inspection?
For April 25th, 2023.
And did you receive consent to do the inspection?
Yes, I did.
And who did you receive the consent from?
The tenants at the time.
Okay. And when you went to the property, did you have your camera or your video camera with you?
Yes, I did.
And did you take a video of your inspection of the property?
Yes, I did.
Okay. And do you have that with us today that we can go ahead and play it?
Yes, I do.
Okay, let's go ahead and play that. Approximately how long is it, so we know?
4 minutes.
Okay, thank you.
Okay, I'm at 414 140th Avenue. This is a FEMA post firm, and I'm going to do a walkthrough of the build-out downstairs, starting with the main door, which is in the back. I went through the gate. I'm going to walk through the main back French doors, stand to the right. So here we're going inside, stand to the right. This is the living space right here. There's the kitchen space right there. Stand to the right. I'm going to walk down this way. No receptacles, or very few receptacles. This is all below the BFE build-out. This is a door right here that goes upstairs. It's locked. They don't have access to that. They have 2 bedrooms here. This is the first bedroom here. That's all been built out, as you can see. No windows, so there's a code issue right there. They do have smokes, if that's working, which I doubt it. Going back out in the hallway, there's no smoke out in the hallway. Going into the other master bedroom, there's a smoke here. Don't know if it works. And they have a closet area. Washer and dryer closet area. You can see they ran their stuff. No permits down here, by the way. I don't even know if that thing's, yeah, no permits for none of this. So we're going back through the hallway. Back out in the hallway and then towards the front. This is the main bathroom. And let me turn these lights on. You do have an exhaust fan, shower, small closet area. And then going back out, now we're going into the kitchen area. So in the kitchen area, they have a full AC down here for the entire floor. And that full AC and hot water heater is put in without permits. There's a permit right here for this that was never closed out because it shouldn't have been issued. And that permit number is 20220352 for that AC unit. And again, they have some issues up there with penetrations above there. I see there's a valve up there off the kitchen lines. And then you have a hot water heater with no overflow pipe on the back of it and no disconnect. So that's all illegal, no permits. And you're going over here to the refrigerator, and then you have a full-size panel down here. I don't know what that looks like, but there's a full-size panel downstairs. It's a 200 amp service downstairs with all the different, that's the build-out part of it there. Let's go this way. And as you can see up there, there's penetrations through the ceiling because everything came from upstairs down. 200 amp panel, no permit for this also. And it looks like it's loaded. So, again, stand to the right. Oh yeah, stand to the right. These windows are non-operable. There's no screens on the windows, but the windows themselves are non-operable. And just before you get back to the main door, you have a egress door here with a key lock both inside and outside, which shouldn't be there. And then you're back to the main doors. We're outside in the patio area. We got a shed out here. Looks to be 8 by 12. A lot bigger than 8 foot high. Anyway. And you have your meter outside. Your power meter's down here, underground service. Main meter's here. And service is going upstairs, plus the panel right behind this wall. So, okay, going around the outside. All the panels out here are covering, so there's no windows on the outside. Walked all the way around the building. Nothing's here. As you can see, it's built out in front. There's no garage doors. These are all just fake panels. All the way across the front. And then your base flood.
Is that it? Or did it just cut off?
Well, it cut off. There's a very little left, but it did cut off.
Okay.
But that's pretty much it.
All right. All the way through this video that has been taken, that's your voice, correct?
Yes, sir.
Okay. The citation for today is for failure to have a building permit for that bottom floor build-out. Have you checked the city's records to determine whether or not a building permit has been issued?
Yes, I did, and no, one hasn't been issued.
Okay. And could one be issued at this point?
For that area, no.
Okay. What is that area supposed to be?
According to the county records, it's supposed to be a Bear with me a second. I think I got it listed. I got it right here. Per the county records, they have it listed as lower area finished, 433 square feet.
Okay, the area that you walked through, was that larger than 433 square feet?
Yes, it was.
Approximately how many square feet has been built out?
Well, and what I've seen, the whole base, the whole first floor has been finished out, and that would be the garage level, which is 923 plus the 433 square feet.
About 1,300 square feet.
Yes, sir.
Okay. Is it possible to someone do a build-out without a building permit and have it grandfathered in because it has been there for a significant period of time?
No, there's no grandfathering in the Florida Building Code and as far as life and health safety concerns.
Okay. So what would it take then to bring this property into compliance if a building permit cannot be issued?
They would have to demo out the bedrooms, the bathroom, kitchen area. It all have to be demoed out.
Okay. And how much time do you think it would take to do the demolition of that first floor?
Less than 30 days.
Okay. And if they don't bring it into compliance within 30 days, what do you think the appropriate daily fine would be for non-compliance?
My opinion, $250 a day.
And what's the reason that you're at the highest range of the daily fine?
Because there's a lot of life and health safety concerns as narrated in the video, especially with the two bedrooms with no second egress, no smoke detectors throughout that were operable, and faulty wiring and plumbing issues,
All right, thank you.
and non-operating windows.
And non-operating windows, is that what you
Yes,
said? Okay,
yes.
all right.
For egress.
I don't have any other questions of Mr. DeSantis.
All right. How did you want to deal with the video, Mr. Trask? to get it
I'm
in?
gonna tender it into evidence.
Okay.
If we can put it on a thumb drive and provide it, tender it into evidence, the city's exhibit number 2.
All right, we'll accept the video in as exhibit number 2.
Thank you.
All right, Mr. Conklin, go ahead.
Thank you. I'm sorry, sir, your last name is
DeSantis.
DeSantis.
Yes, sir.
Mr. DeSantis, did you actually try to open the windows?
Yes, I did.
Okay, and you could not operate them?
No, sir.
All right. Also, you said that the county records for this, you said that was what, the building standards? I'm not sure I understood that.
I don't understand your question.
Well, you said according to the county, they were only permitted so many square feet?
No, what I said was per the county's records, the lower area finished floor was 433 square feet, and the garage area was 923 square feet, that's what I said.
All right. You said that you checked for a building permit for the first floor. How far back did you go in your search for the building permit?
I went back since I started 2014 and 3 years before that when Quorum Services was working for the city.
Okay. Are you aware of when this building, the house, was built?
According to the county records, 1989.
Do you know who the owner of the property was in 1989?
No, sir.
Okay. Are you familiar with a name of Robert Pensa? Do you know who that is?
No, sir.
Okay. He was the owner of the property in 1989. He was also the assistant building director for Pinellas County. I know that because I was assistant county attorney from 1977 to 79. Mr. Pensa was the assistant building director. So you don't know if Mr. Pensa built the house?
I could not tell you.
Okay. And you certainly don't know who put in the improvements on the ground floor, the first floor?
No, sir.
Okay. You made no inspection of the second and third floors?
No, sir. We had no access to it.
Okay. And did you find anybody residing in the second and third floors?
At the time of inspection, no.
Did you do a subsequent inspection?
I'm sorry?
When you said at the time of the inspection, it leads me to believe you did more than one inspection.
No, sir, I just did that one
Just did-
inspection.
Just did the one. Were, in your research of the city records, did you note a code violation notice for this property for September of 2013?
No, I did not.
So you would have no knowledge as to the outcome of the alleged code violation in 2013, is that correct?
That's correct.
And in 2013, the property was owned by my clients, Ms. Santos and Ms. Volpe, correct?
I
Don't know?
don't know, 2013.
All right. I have no further questions. Oh, I'm sorry, what, one additional one. How did you test the smoke detectors?
I observed no batteries in both ceilings, and there was no smoke detector outside of both bedroom doors.
What if they were hardwired?
Still have to have a battery in them. They won't operate without a battery. That's a backup.
Thank you. No further questions.
Mr. Trask, anything else?
I have nothing else. The city would rest at this point. We have no further witnesses.
All righty. Okay, Mr. Conklin, how would you like to proceed? You can call witnesses. Do you want to present evidence, argument? You tell me how you want to proceed.
I'm going to present evidence.
Okay.
Thank you. I'm going to call Mr. Greg Clark, and he has been previously sworn. Mr. Valdez, I haven't appeared before you before. Does he stand beside me? Does he sit there? What-
He will need to talk into a microphone, so as long as, just stand close to each other right there at the podium unless Mr. Trask has an alternative way to do this. But
Well,
I would
Mr.
just
Trask
say
was kind enough to provide an additional microphone.
that'll be fine, so, yep, that'll work.
You want to take that to seat, or?
Yeah, I'll take it over to a place where everyone can see me.
Okay.
Sit right there. That makes it comfortable. That works for me.
And, Mr. Clark, would you tell the magistrate how you were employed?
Yes, I'm a licensed attorney. Hello, can you hear me? Oh, yes, my name is Gregory D. Clark. I'm a licensed attorney at law practicing in Clearwater. I was admitted in 1981 in October and have been employed for the past 42 years as an attorney.
All right. And, Mr. Clark, by whom are you employed? In this case, by Ms. Volpe and Ms. Santos?
Yes, yes.
Okay. And did you perform a title search of this property?
Yes, my engagement was about 10 years ago, and at that time, they came to me with regard to the 2013 code enforcement violation notice they got, and I did a title search at that time.
Okay. And Mr. Clark, in your notebook, and I can provide copies, I certainly have no means to have them published on the screens, but the first deed that I showed from George Shantz and Patricia Shantz, dated July 18, 1983, to Robert Pensa. Do you see that warranty deed?
My search did reveal a deed where he acquired title. You want to show it? Oh, there's...
Go backwards.
One thing that comes with advanced age is the need to read fine print. Yes, I see a deed dated July 18th, 1983, from
All right.
Shantz to Pensa.
And do you know who Mr. Pensa was?
Well, I found out subsequently that he was a head of building, I guess, director of building at Pinellas County.
All right. And in your research, was Mr. Pensa the person who built this, the home, the residence?
Yes, he was.
Okay. And in your research, were you able to find anyone other than Mr. Pensa who would have built out the first floor?
I can't imagine anybody else other than later in the chain of title. There was a Schaefer, I think, that came
Okay.
into title.
And in fact, that's the next deed that I have. Robert Pensa, unmarried, to Michael and Dane, it's D-Y-N-E, Schaefer, S-C-H-A-F-F-E-R, husband and wife, stated December 4th, 1998. And do you see that deed?
Yes, I do see that deed.
And that was part of your search of the
Yes.
property? Very good. And then subsequently, the next entity in title was Wells Fargo Bank through a foreclosure. Is that correct?
Yes, a certificate of title issued July 8th, 2008.
Okay, and Wells Fargo, as trustee for option one, they received the certificate of title, and then Ms. Volpe and Ms. Santos obtained the property from Wells Fargo, is that correct?
Yes. in,
By special warranty deed?
Yep, March 17th, 2009,
All right,
St. Patrick's Day.
and they are the owners to date?
Yes, sir.
Very good. And Mr. Clark, did you represent Ms. Santos and Ms. Volpe back in 2013?
Correct, I did.
And at that time, was that concerning a code violation notice issued by the city of Madeira Beach?
Yes, it was.
And the violation was?
I believe it's the same thing that we're at about today, is the build-out of the downstairs.
Okay. And, Mr. Clark, what happened with the code violation charged by the city of Madeira Beach in 2013?
Ultimately, it was dropped. The city did not pursue it, but we had representation going on for several months and had several discussions with city officials at that time. I don't know if any of them are still employed here, but ultimately, the city, I believe, decided that this was a grandfathered situation, and they did not pursue the...
Objection, speculation.
All right, I'd like to see the document you're referring to, Mr. Conklin.
Certainly. If I may approach?
Sure. Thank you. Just give me 1 second. All right, Mr. Trask, have you seen this document?
I apologize, Mr. Best, I've not seen any of this. I was retained Thursday.
Okay, no problem. All right, the objection was to the testimony about why the city dropped the or pursuit of that. Unless Mr. Clark can provide some sort of direct knowledge as to that, then I'm going to go ahead and sustain the objection based on speculation.
Well, I think there were actually inherent two objections. Mr. Clark testified that the city had dropped the matter. I don't think that was speculation. But as to the reason why,
That's what I thought the objection was, is to the reason why the city dropped it. If you guys want to, I mean, all I've seen so far is a notice of violation. I haven't seen anything disposing of the case yet.
how was the case disposed of? Was there
Well, I
any
actually
order
sat
of,
down, I sat down with the city official at that time. Her first name was Lynn, and I'm not recalling her last name right now.
Rossetti, R-O-S-E-T-T-I?
Right, Rossetti. I think she was the director of the building department in some capacity. And we discussed the matter as a grandfathered issue of long standing. And she couldn't confirm to me at that point in time. Actually, she wouldn't really say a whole lot about it, but at that point in time, I said, listen, you've charged us with something. If you're going to bring it now, bring it to court. But we believe we have grounds for grandfathering in on this issue. And at that point in time, I think she just let it go. I'd never had follow-up with her at that point in time. And so the city dropped it at that point. And that was a direct conversation I had with her face-to-face at a meeting.
And that meeting was September 14, 2014?
Yes, I related it in a memo that I did, an email to my clients to report to them the findings of that meeting with Lynn, and I have that with me today.
All right. At that time, did Ms. Rossetti have any of the building plans for this house?
No, she did not have any of the building plans. And I understand that today there's no record of the permits that were issued, and something to the effect that the county and the city destroyed their records after a certain period of time.
All right. Mr. Clark, what's contained in the notebook that you have there?
This is a collection of the emails I had communications with my client back and forth over this matter. They started approximately in September of 2013, and they went on for about a year. So the email communications document the process of the efforts we made with the county or with the city to resolve this matter at that time. It was clear at that point back in history that Madeira Beach wasn't in charge of the permitting for this property when it was built, that the county handled it. In fact, the county official in charge of building was the one who was the owner and pulled the original permit. So I've got a number of records here that I preserved. In fact, I've got my original paper file that goes back there. And fortunately, some of the records have been kept as far as I'm concerned. I didn't destroy my records. So yes, I do have comprehensive information.
Okay, and they were kept in the regular course of your business
Yes, yes,
with a duty to do so
yes,
and contemporaneous to the events?
yes, exactly.
All right. Mr. Magistrate, I don't know, Mr. Valdez, how you want for me to offer these into evidence at the end. I know that Mr. Trask hasn't had an opportunity to review them. I don't know if he wants a continuance for that purpose. But the point being, at the end here, I have certified copies of the 4 deeds that I discussed, and I'll submit those, as well as the emails that Mr. Clark prepared regarding to the case and the code violation and his meeting with Lynn Rossetti in September of 2014, which also includes then his email that to his clients that the matter was concluded and that the city was not pursuing it any further. And so if that's,
Let's start with this. Why don't you show the documents to Mr. Trask first? Let's start there.
I will be pleased to do so. It is probably over about 120 pages.
I have no objection, first of all, to the deeds. As I'm going to go through, I'm just going to mention. I do have objection to the code violation notice. It's not relevant to the case. That was for a different code violation. That was for short-term rental. It's very specific. It's a short-term rental. It's not a building issue, so that's irrelevant. If all these emails are in direct relation to the code violation notice for the short-term rental, I would object on the basis of relevance. This is not a short-term rental case. This is a failure to obtain a building permit. So, Mr. Conklin, are any of these emails about a building permit violation, or are they all the short-term rental case?
Also about building violations.
I'm
And
sorry?
Also about building violation. Mr. Clark's conversations with Lynn Rossetti specifically were regarding whether these structures on the first floor were permitted.
Can you point that out to me so I don't have to look through every one of these? If it's something other than short-term rental, if you could point it out to me?
Figure I'll go one at a time.
That's not about building permits.
You say this is false, this is what the city is. You were replying to what the city said.
Okay, I've had an opportunity to review the documents with Mr. Conklin. There are a number of exhibits that the city would have no objection to, and I'd just like to go ahead and go through them with you, because I'm not sure how they're actually going to pull them out. But
This is what I was discussing with Mr. Clark. This is Mark, Attorney Clark. We're waiving that.
okay.
This is results of this meeting with Ms. Rosette.
Okay. So I'm just going to read into the record, if that's okay with you. So there are circled numbers on the documents. Some of them are 1 or 2 pages. I have no objection to the following documents. All of the deeds that were referenced, item number 53, item number 35, item number 59A1, item number 70, item 99, item 102, and item 104. I would object to the other documents that are being tendered in evidence. They have no relevance. They're having to do with discussions relative to a code violation for short-term rental at the property.
All right, Mr. Conklin, do you want to move everything in, and I need to?
I want to move everything in, depending on your ruling on the admissibility. I still want to have them part of the record, and that the other documents then would be a proffer.
I have no problem with that. Let me see the documents. We'll go ahead and I will move into evidence the documents that Mr. Trask just identified as him having no objection to. Mr. Conklin, stay there for me if you don't mind. Just help walk me through these. So the warranty, the deeds are up front, and these the city had no objection to, correct?
Correct. Purchase between, I think it's like almost 9 years. This is when the house was built.
Okay, so I think I understand what you're telling me. All right. What about this document, 14A? Is this one that Mr. Trask objects to?
I believe it was.
Yes?
Let me look at the other documents before I make a ruling on that, okay? What about this 20A? Is 20A objected to?
Mr. Trask was keeping records while I was flipping the pages.
Yeah, please come over, Mr. Trask. I want to make sure I get this right.
So that was not, I objected to that.
Okay, so these two, those are in dispute.
The first page that I have no objection to is page 35.
Okay, so I need to look at these and give you a ruling on these, okay? And then how far, 30, is it just 35, Mr. Trask, or where do I need to start looking again?
So the next one was 53, which I had no objection to.
Okay, let me just go through from, just to get my ruling on the record from 14A to 34. All right, 14A is the code violation notice. I mean, it does reference in violation text, home advertised as rental property coupled with base level converted into a habitable space. I'll go ahead and let 14A into evidence. 20A is a letter from Mr. Clark to the city of Madeira Beach, just a letter of representation. I'll allow 20A into evidence. Mr. Clark, who is K. Risco at AOL.com? Is that somebody in your office or was in your office?
Can you go to the microphone so we can get this on the microphone over there? Thank you.
Kay Osman? Yeah,
It's this right here. You see that, Mr. Conklin? I'm just trying to understand who the recipient of this particular email is. Yeah, go ahead. Sure. All right, I'm going to sustain the objection as to 21. Exhibit 22 is just a request from Mr. Clark for an extension on the reinspection. I'm not sure how those are relevant, so I'm going to sustain the objection to those. 22A appears to be the same code violation as 14A. Is this different, Mr. Conklin, or is this just another copy of the same thing that I already allowed in?
It's just another copy. This is the way.
Understood. Understood. '23 is the email from William Lawson to Mr. Clark discussing an on-site visit. I'll allow that into evidence. Number 24 is another email from Mr. Clark to Mr. Lawson. Since this email discusses actual improvements and discusses them being pre-existing, I'll allow that into evidence. '25, I'll sustain the objection. It's hearsay and not relevant. Same for '26. In regard to the document that is 27 and 27A, if Ms. Santos can authenticate these photographs, then I'll let them in, but absent having a witness authenticate them, I'm going to sustain the objection for now. I'm going to sustain the objection to 28. Excuse me, I'm sorry. 28 is an email between Mr. Clark and his client, Ms. Santos. Yeah, this is just talking about her health condition and indicating she's living on the ground floor. I'll sustain the objection to that. Sustain the objection at 29 on relevance ground. And 34 based on hearsay. So now I need to go to 36, is that right, Mr. Trask?
35, I had no objection to.
Okay, so 36 through 50,
Next one I have no problem with is 53.
okay. I'll allow in number 36. It talks about improvements such as a bathroom on the ground floor. Thirty-seven looks like it deals with a dock variance. I'll sustain the objection. Thirty-eight, I'll overrule the objection and allow it in. Thirty-nine looks like just an internal email, therefore based on hearsay, sustain the objection. 40, I'll sustain the objection. Forty-one, I'll sustain the objection. Forty-two, I'll allow it in. Forty-three, I'll sustain the objection. 44, I'll sustain the objection. 45, I'll sustain the objection. 46, I'll sustain the objection. These all just appear to be internal scheduling emails between Mr. Clark and the respondents. 47, I'll sustain the objection. 48, I'll sustain the objection. 49, I'll sustain the objection. 50, I'll sustain the objection. 51, I'll sustain the objection. 52, I'll sustain the objection. All right, and then we get to 54. Is that the next?
53, no objection.
Okay. Fifty-four appears to be something relating to boat dock, so I'll sustain the objection on that. What about, I see a 54, like A1, or is 54 all one document, Mr. Conklin? All one, and you object to that, correct?
Yes,
Mr. Trask?
the next document that I have no objection to is 59A1.
All right, this all appears to be something to do with a variance for a dock. So I'll sustain the objection as to 54. Same for 55 and 55A. So where am I going to next? Mr.
59A1.
All right. 56, I'll sustain the objection. 59A1,
No objection.
all right. That'll come in. 59. So 59, you have no objection to, right, Mr. Trask?
Just 59A1.
Just 59A1. '59 is discussing the dock situation, so I'll sustain the objection. '61, I'll allow it in because it discusses they purchase the property downstairs with the downstairs infrastructure already in place. Are there any more you agree to, Mr. Trask?
70, 99, 102, and 104.
All right. 63, I'll sustain the objection. 66, I'll sustain the objection. It deals with the short-term rental issue. 67, I'll sustain the objection. It looks like just a draft email. 68, I'll sustain the objection. 69, I'll sustain the objection. And it looks like I'm jumping to 76, is that right? I'm going from 70 to 76.
70.
Okay, and you have no objection to 70, correct?
Correct.
Which is the next one you do not object to, Mr. Trask?
99.
Okay.
They jumped because I pulled out some that were attorney-client.
All right. 76, I'll sustain the objection. '77 and 78, I'll sustain the objection. '79, I'll sustain the objection. These are talking about grandfathering in the property as a short-term rental. Same with 80. And I'll allow 80A into evidence. This just says that this is the letter indicating that the property was grandfathered in with regard to short-term rentals. So I'll overrule the objection and allow 80A into evidence. 81 I'll sustain the objection. '82, I'll sustain the objection. And I'm jumping to 93,
99.
okay? I'll sustain the objection to 93, because again, it looks like it talks only about short-term rentals. I'm going to overrule the objection to 98, allow it in. All right, what about 100, 101, 102, 103, 104? Do I need to
No
rule on-
objection to 102 or no 104, no objection.
Okay, so let's do 100. All right, 100 just appears to be a scheduling email. I'll sustain the objection. '101, I'll overrule the objection and let it in. '103, I'll sustain the objection. And 104, I think there's no objection, but I
Right.
just wanted to read it, so, thank you, sir. And I did read 104.
Are you going to leave those documents,
Yes.
Mr. Conklin?
Yeah.
For the special magistrate?
Yes,
Okay,
I'm just using them because I only have one for myself.
okay.
All right, Mr. Conklin, I believe I gave you a clear ruling on every document. I just want to get that in the record. Have I given you a definitive ruling on every document that you
You
wanted?
have, sir.
Okay,
And as
so
to the others, I'd submit as a proffer.
I will go ahead and accept those in all to the record, and we'll do it as Respondents Exhibit A, just to make it different. Obviously, refer to the transcript as to what documents were admitted into evidence and considered by me. As you saw, again, for the record, I went through page by page and read every one of the ones that were admitted into evidence. So I have considered those as part of the record today.
Thank
You may proceed, sir.
Thank you. Mr. Clark, going to Exhibits 104. You met with the city official, Lynn Rossetti, and would you summarize for the magistrate the outcome of that meeting?
Yes, the upshot to the meeting was that we discussed specifically these FEMA requirements and the build-out, and she declined at that point in time to not only talk about them, but to indicate what direction she was going to go with as far as they're concerned. I pointed out to her that the length of time that had passed and questioned exactly, for example, well, the chapter and verse and time of the particular law in question that was being violated, seeing that this property was originally permitted back in 1984. They didn't finish construction until 1989. And as far as I could tell, all this build-out had been done at that time and was perfectly legal. But without the city giving us a specific bright line as to when the law is that they're complaining about, which is 20 plus some years later from the construction, there was really no basis for the, city to go forward with this violation. So at that point in time, this is the last conversation I had with the city. It was a face-to-face sit-down with Lynn, and we did not receive any follow-up after that. There was no further prosecution of this charge, and so it was a surprise when it shows up here 10 years later after that conversation.
Back in 2014, had you inspected the property?
Had I?
Yes.
Yes, I had taken a look at it, but I tell you what, my memory is so dim on that.
And it was as built out as described by the building inspector today? 2 bedrooms, bath?
Yeah, you know what? I'm not going to stretch my recall on that. I think the clients themselves can testify better to that, so I just don't recall that.
Very good. I have no further questions.
Mr. Trask, you may inquire.
I don't have any questions of Mr. Clark.
Okay. All right, Mr. Conklin, who would you like to call as your next witness?
Ms. Volpe? Or whichever one.
I think they said the email was back.
Very good.
Teresa?
Ms. Volpe, either you or Ms. Santos, did you do any construction on the first floor level?
No, we've never changed anything structurally. We purchased the property that way.
Okay. And you heard today that the windows didn't open. Have you opened those windows?
Yes, the windows do open.
All right. And I'm sorry, I'm looking for the photographs. Yeah. Thank you. Mr. Valdez, we're turning to 27A. Obviously, I have the book. Those are the photographs that you'd asked about. Ms. Volpe, can you tell me whether you or Ms. Santos took these pictures?
We did not take those. Our mortgage company did.
Okay. Can you tell me that back in 2009, where these photographs that are depicted on 27A, do those accurately represent what the property looked like in 2009?
It looks like that then, and it looks like it now. The toilet is actually the same toilet. The water heater is the identical one. We've never replaced a water heater. There's an air conditioning unit. The bedrooms are there. The same fans that were there now are in the place right now.
Okay, so basically you've made no changes.
Other than painting and carpeting and changing some cabinets, no.
All right. As to then the photographs at 27A, I would submit that I've now authenticated the photographs.
I believe she has, so I'll go ahead and allow those photographs into evidence. I think they were identified as 27A
27A.
in your book. All right, they'll be.
And there were
available.
2 pages of the photographs. All right, and Ms. Volpe, was your recollection of the alleged violation back in 2013 and 2014 just as Mr. Clark has testified? In other words, it was also not only about the short-term rental, but also about the alleged improvements on the ground floor?
Correct.
And to your knowledge, has there been any further action by the city of Madeira Beach as to that 2013 and 2014 alleged code violation? Not counting this proceeding, of course.
Yes, not to my knowledge. We were, when we heard it was just ended, we just thought it was taken care of.
All right. I have no further questions.
Ms. Volpe, I do have a couple questions before Mr. Trask asks you any questions. Is there anyone living on any floor of the property right now?
Well, it is, it's our second home, so we do occupy the upstairs. We occupy the whole home. It's a single-family home. It's not 2 units. It doesn't have separate electric meters or water meters. Nothing is separate. So we do occupy it when we come into town. We come for the summer. We come at holidays. So we do occupy the single-family home.
All right, ma'am, also, I saw on the video the electrical panel. I recall that portion of the video. Have you guys done any work on that electric panel since you moved in?
No, not that I recall. If there was any work done, we always had, for instance, the air conditioning is an air conditioning unit that may have had, we've had repairs on it. And if there's any work done that way, they may have touched it. I'm not sure. But it is one panel for the entire house.
The air conditioner, it looks like what I saw in the video is a newer air handler than what was in your pictures. Have you replaced the air handler since you guys?
Correct. It was
bought the property?
it was a replacement for the air handler.
I want to make sure I heard your testimony correctly. The hot water heater, you said is the same one that was there when you got there because Mr. DeSantis took issue with some
It's a really
connection
good hot
issues.
water heater. It's 15, that we know of, 15 years old. It may be older, but we've never replaced it.
In the rooms that were shown where Mr. DeSantis took issue with not having windows in those rooms and smoke detectors outside, who occupies those rooms?
Well, our friends, when they come to visit, our family visits, my sister, we purchased the home because my sister had, she was sick and she needed to be on a level that she didn't have to go up and down stairs like the home she was living in, so she stayed in those rooms. Yeah, so that's family members.
When you purchased the home, do you ever remember getting disclosures from the seller? Did the seller say anything about whether all the work was permitted as part of their disclosures to you?
No, it was a foreclosed property.
Okay, I thought I saw a certificate of title
Yeah.
in there as well. All right.
I'm sorry, I don't mean to interrupt. The deed into Ms. Santos, Ms. Volpe, is a certificate of title from foreclosure by Wells Fargo.
Got it. All right, that's all the questions I have for Ms. Volpe. Mr. Trask, you have anything?
I have a few questions. Ms. Volpe, do you have any copies of any building permits ever issued for work done on your home?
Do we have copies? I would like to defer to Mercedes Santos because she handles more of those things. I'm not sure.
You don't know?
I don't know.
Okay. And with regard to the downstairs, have you had tenants in there in the past?
Yes.
Okay.
This past season, whatever this was, starting in September.
How many different tenants have you had in your property on the bottom floor?
We've had 2.
Okay, and how long have you rented the bottom floor for?
It's always 6 months plus.
Okay, so in the last 2 leases that you have for those tenants, how long were they?
They were both for 6 months plus.
I don't understand that. Does that mean it was for 12 months, for 18 months?
6 months and 1 day.
And what were the names of the individuals that you rented to?
Kenneth Nelson and Dan Gavir.
Can you spell the last name?
For Gavir?
Mm-hmm.
Gavere, I believe.
They weren't related to you in any way, correct?
No, they're not related to me.
Okay. So at some point then, you and your family were on the top 2 floors, and Mr. Nelson and Mr. Gabir were on the bottom floor, correct?
Not at the same time.
Okay. Well, they weren't renting the top 2 floors from you, were they? They were just renting the bottom floor,
They
correct?
were renting the bottom floor.
Okay. So in the entire 6 months that they were there renting that bottom floor, are you saying that you never lived on the top 2 floors?
Correct. I did come, my brother had emergency surgery, and I did arrive during the holidays, and we did stay upstairs for 7 days.
Okay. So you don't dispute then that it was used as a home that had 2 units in it? The top 2 floors were yours, and the bottom floor, what you rented out for 6 months and a day?
I do dispute that because they were more than welcome to use the yard. If they had wanted to be upstairs, they could have rented upstairs and paid extra. They could go upstairs. But at that point, that's how we rented it to them. That was how they wanted it.
Okay. They only rented the bottom floor?
At
And
that time, yes,
they had no access to floors 2 and 3, correct?
correct.
Okay. And you heard the building official talk about the permit that is taped to your air handler as being applied for but not inspected and finalized out. Do you remember that testimony that he had?
I do
Okay.
recall that.
And you admit then that that permit that is on the air handler was placed there by you or someone in your household?
No, it wasn't. It probably was from the person who came to do the repair.
Okay,
They were the ones who, it sounds like, from what I recall, went and got the permit.
okay. Do you know whether or not it was ever finalized out?
I do not know.
Okay. So if we were to take a look at that hot water heater and see the date on that hot water heater as being something other than 15 years old, was that hot water heater replaced?
I don't know. And we have never replaced the water heater.
Okay. As for the cabinets you said that you replaced, did you get a building permit for that?
No,
Okay. Did you do any other electrical or plumbing work on the bottom floor?
no.
Okay. I have no other questions at this point.
Mr. Conklin, anything further with Ms. Volpe?
No, Your Honor.
All right. Ms. Conklin, you go ahead and call your next witness.
I may confer with Mr. Clark for a moment.
Okay.
I have no further witnesses. We'll rest.
All right, stay right there, because I do have a question for Mr. Clark as I was thinking about it. Mr. Clark, in performing your title work for the owners, did you ever come across any notice of commencement or any other document that would be evidence of work being done on the property that you would expect to see recorded in the public records?
I actually have the certified title report that was done by the fund back in 10 years ago. I don't know if it would make more sense to take a look at that right now out of my file to refresh my memory. I would
Yeah,
like-
please do. Or, and if you're seeing anything that would be a claim of lien that some contractor or subcontractor would have filed, or anything along those lines.
I'm surprised I haven't found any silverfish in here. This hasn't been opened in 10 years. All right. Let's go ahead and go through it. This particular report goes back to 1974, which is the records for the fund title insurance services. That's where pencil had it. There. 1983. See a notice of commencement anywhere?
No.
Take another quick look at it. There looks like to be a notice of commencement in 2002.
Is there a contractor noted on that, or any scope of work noted on that one?
Unfortunately, I just have the summary report, and
Okay.
on the report, it does, that's a good question. No, there's no contractor mentioned on the summary, but there would be one on a notice of commencement, the actual document.
I'm sorry, I cannot hear you. What did you just say? You can speak in closer.
Yeah, it's the notice of commencement. This is a summary report, title report from the fund, and it does not indicate a contractor. What I mentioned is that the actual document itself, as recorded, would proper notice of commencement would indicate who the contractor was.
What's the OR book and page number? We'll pull it up right now.
We have a OR book of 11906, page 2552. And the date of this notice of commencement was March 25th, 2002.
Okay, Grace, can you pull that up? Okay.
Okay, that's it. I didn't see any liens or any other documents other than mortgages, mortgage satisfactions, assignments, deeds, and such.
All right, thank you, Mr. Clark. Mr. Conklin or Mr. Trask, do you have any follow-up questions with Mr. Clark based upon the questions that I asked him? We'll start with Mr. Conklin.
No, Your Honor.
No.
All right.
Are we waiting for Grace to pull that up?
Yeah, I'd like to while we're still in
Okay.
the respondents' response portion of the hearing before we go to public comment.
I have some rebuttal too, by the way.
Okay. What we'll do is we'll go to the, you want to do rebuttal first or public comment first? I don't,
I'll do the rebuttal first.
okay, we'll
Yeah.
do rebuttal. And then what we'll do in regard to closing, I want to give you guys the opportunity. The city will go first, since as a burden. Mr. Conklin, you'll go, and then Mr. Trask will be allowed a reply. Okay? I need to get closer to one of these screens.
Yeah.
For the pools, yeah. All right, so the record's clear. The notice of commencement appears to be related to a pool on the property. All right,
And just so you note, the time period, that would be when Mr. and Mrs. Schaefer owned the property.
I did note that Mr. Schaefer was listed as the owner. All right, thank you, Mr. Conklin. You can have a seat.
Thank you.
We will go to the city's rebuttal case first, then we will have public comment, then we will do closing arguments.
I'd call Mr. DeSantis again. So, Mr. DeSantis, you've heard the testimony from both Mr. Clark and the narrative that was given by Attorney Conklin, and you've also heard from one of the property owners. Let's talk about the building permit issue first. Was there ever a building permit issued that you're aware of for that bottom floor?
The only one I'm aware of is the AC unit.
Okay. And the one for the AC unit, we've heard some testimony on, that was when?
I don't know off the top of my head.
Okay, if you could turn to item docket page 31, which is the Pinellas County Property Appraiser website, and it lists permit numbers there.
Yep.
You see where I'm referring to on page 2?
Yes, yes,
Which
sir.
is actually page 31 of the docket. It's showing that there was a mechanical permit that was applied for in April of 2022. You see that?
Yes, sir.
Is that the one that you're referring to in your testimony in the walkthrough, that the final inspection was not completed?
Yes, sir.
Okay. And the reason why it wasn't completed was what?
Because the contractor never called out the final inspection.
Okay. So that's just an open permit at this, actually, it's expired, correct?
Yes, sir.
Okay. So they'd have to apply for it again?
Yes, sir.
Okay. And under the law as it is today, Florida, would they be able to get another HVAC permit for the location where it's at?
Knowing the location where it's at, no.
Okay. You've also heard testimony about the windows opening. When you were at the property, was there some effort that you had to apply to try to get them to open? Because obviously the property owner says they're opening, you're saying that they're not. Can you explain that?
When I was at the site, excuse me, when I was at the site with the tenants, we tried the windows and they did not open and the screens were missing.
Okay. And with regard to the bedrooms, under the Florida Building Code or the city's code, is there a requirement that the bedroom have a window or two means of egress or ingress, egress out of it?
Yes, sir. Two means of egress
Okay.
per bedroom.
So they'd have to have a door going in and either a door going out or a window going out?
Yes, sir.
Okay. And the window has to be at a certain height, correct?
It's got to be 44 inches from the finished floor, the bottom of the window, and it's got to be a minimum 5.7 square feet opening.
And neither one of those bedrooms have that window, correct?
Yes, sir.
Okay. So was there at some point in the history of the Florida Building Code where you were allowed to have a bedroom on a bottom floor with only one point of egress?
Not that I'm aware of.
Okay. How long have you been a building official altogether?
I have my building official license since 2009.
Okay,
I have a state license since 2003.
okay. So when you say a state license, is that a general contractor's license?
I'm sorry, it's a state mechanical license, air conditioning.
Okay, all right. Okay, I don't think I have any other questions for you, Mr. DeSantis.
Thank you.
Mr. Conklin, any cross?
Yes, thank you. Mr. DeSantis, did you find the original building permit for this building?
Did I find it?
Yeah.
No, sir, I didn't look for it.
All right. Point being, the building permit and the plans submitted with the building permit, that would show any construction build out for the first floor, is that correct?
No, sir. It's called an equal change out. It's a same-day permit. If you came in front desk, equal change out, give you a permit. Simple.
Okay. And you did not look for that permit to see which of the owners built the property, whether it was Mr. Pensa, Mr. and Mrs. Schaefer?
I did not look at the permit, no.
Okay. I have nothing further.
All right. Mr. Trask, would you like to call any other witnesses in the city's rebuttal case?
No.
All right, any other documents you'd like me to review?
No.
And I just want to make sure that as we go both to public comment and the closing, when I go back and look at the notice of code violation, the violation detail had three components to it. One, the ground floor level of the property has been posted unsafe for human occupancy. The second bullet point was work has been done at the ground floor without required building permits. And three is that the property must remain a single-family dwelling. But I believe that third bullet point was related to the section 110-177 violation.
That is correct.
So the city is asking me to find that there's a violation based on either or the ground floor level of the property has been posted unsafe for human occupancy, or work has been done at the ground floor without the required building permits, or is that one in the same violation?
It's one in the same violation.
Okay. All right, I just wanted to get clarification on that. All right, this is the point in the hearing where I will hear any testimony from members of the public who are affected or have personal knowledge of this code violation. Any members of the public that want to come forward? All right, seeing there is no one coming forward, we'll go ahead and close public comment. And Mr. Trask, I'll let you do a closing argument, and for the benefit of both Mr. Conklin and Mr. Trask, if you have the ability to argue it, I'd like to know the law as it relates to grandfathering in of things that are either health, safety issues or a violation of the code. I'm certainly familiar with case law dealing with grandfathering in as it relates to properties built in a setback or even certain special uses, vacation rentals, things like that. But when there are health, safety issues or violations of the building code, I'd like to hear argument on that. And if we need to do supplemental briefing on that, we can do it as well. But I want to get to this issue that the respondents are raising, that they can have work that is, the city is saying renders the property unsafe, or work that was never up to the building code that is a health, safety issue, that can be grandfathered in. I'd like to hear argument on that at some point. So, Ms. Trask, go ahead.
So I think that the testimony and evidence is clear that there is a violation of Section 8652 of the city code for failure to have a building permit for this bottom floor. You've heard testimony from Mr. DeSantis that he has checked the city's records. There is no building permit issued, and therefore there is a violation there. As for the grandfathering argument, grandfathering arguments are those types of arguments that are made when something was legal at the time when it was originally built, installed, and most of the time it's an argument of use. Can you use the property for? It has to be legal at the time when it was originally done. Therefore, if there was never a permit for the first floor, the grandfathering argument cannot be used because it was not legal then, therefore it cannot be legal now. Unlike a non-conforming use, someone built a building and the building was used for the purposes of, let's just say, a multifamily property, and now it's been zoned single-family property, they can continue to use that property as multifamily because of the fact that it was used as a multifamily, it's been consistently used as multifamily after the time the zoning has changed. And you'll remember that with regard to grandfathering, the grandfathering has to exist legally before, legally now, and it also has to maintain that legal status all the way through its use from the day beginning to day end. And in this particular case, you've heard argument that no, there is no building permit, therefore it is not a legal use, therefore it cannot be grandfathered. As for all the testimony relative to the conversations that Mr. Clark had with regard to Ms. Rossetti, I think it's interesting that those conversations took place. But Ms. Rossetti, you've not heard testimony that she was the building official. She was not. She was the planning director, as I think Mr. Clark made note of. She does not have the ability to make a determination as to a life safety issue when it comes to building. So, and I think that it's interesting to note that the argument in the very beginning was that, well, this is the exact same violation that was discussed back in 2013, when that's not what the evidence has shown you. What you've seen so far has been tendered evidence that was a short-term rental case. And as you know, in your cases that you've tried here before or heard tried here before, those are those cases that were sometimes used as short-term rentals in the very beginning before the law changed in the state of Florida back on June 1st, 2011, and they remain not short-term rentals all the way through time, therefore they are grandfathered. That was the discussion evidently in those emails and those conversations. It was not about whether there was a building permit issued. And you'll note that on some of those documents that you received in evidence, there was very clear discussion relative to FEMA and the requirement that interior walls had to, I believe that it was item number 104, if my memory is right, in your packet, that the interior of the downstairs had to be modified to bring it back compliant with the law. That being our argument, we believe, and you've heard the testimony of Mr. DeSantis, that The bottom floor can be brought back into compliance with the city code and with the building code if it's brought back into the status of being a finished garage at 433 feet and then open garage at whatever it was, 900 square feet. We believe that that can be done within 30 days. We are very concerned about the life safety issues that you've heard a little bit about today, because even though Ms. Volpe was trying very hard to point out that the home is a single-family home, it's obviously not a single-family home if you're renting out the first floor and you're living on the second and third floor. So that's a 2-unit. Now, I understand the fact that we're not moving forward for that particular code violation that was originally cited in the courtesy notice and the notice of violation, but the reason I bring it up again is that you have people that are going to be living on this first floor that if there is a fire, there's no way to get out of those bedrooms other than through the door. So if the fire is in front of the door, those people will suffer whatever is going to happen with regard to that building burning. So that's a major life safety issue. You've also seen that and heard from Mr. DeSantis about the openings between the first and the second floor. That's a violation of the code. You've seen the HVAC system that the application was applied for the building permit. It was not completed. That's a violation. And you've heard all the other things that Mr. DeSantis testified to as he went through the property. So I'm mentioning those to you because I think that those are critical in determining what the dollar amount of the daily fine would be. This being a life safety issue that we're asking for you to find the violation and issue a daily fine in the amount of $250 a day for every day that it remains in noncompliance. Okay?
And Mr. Trask, do you want to address this argument that was brought up in the very first cross-examination about, I think, a juxtaposition of a couple of the numbers on the address for the house and the,
So,
I think it was a notice of
yeah,
violation?
I'd love to cover that. The courtesy notice has the correct address. The notice of violation has the correct address. The notice of hearing, which was brought to your attention, has an address of 1414, but obviously the notice of hearing was received. We've had Mr. Conklin and his clients here. They've had adequate ability to put on their case, cross-examine witnesses, and I think that's a non-issue at this point.
All right, Mr. Trask, I will give you the last word. Mr. Conklin, this is your opportunity to come up. And again, I would ask you to address that same issue that I asked Mr. Conklin on that legal issue.
Thank you. No, I have not looked at it for a while. You had stated there could be a supplemental briefing on it, and I would ask for that. As far as the case in chief, Your Honor, if it please the magistrate, what we've talked about here is a ownership of the property, and I've, have the 4 deeds, and it goes back to, trace back to Robert Pensa, who took the property in July of 1983, and he owned the property until he sold it to the Schaefers in December of 1998. It was our position and the testimony of Mr. Clark that it was Mr. Pensa who built the home, and I asked specifically of Mr. DeSantos, the building inspector, did you look for the building permit for the original construction of the house, which would have confirmed Mr. Clark's testimony or disputed Mr. Clark's testimony that it was built by Mr. Pensa? I stated, and I believe Mr. Clark confirmed it, and that was Robert Pensa was the building head, the director of the building department of Pinellas County, and all during this period. The point is, if we had that, if the city had presented the original building permit, it would have shown then either, I asked Mr. DeSantis, would it have shown the construction of the, first floor? And he said, no, this is a one-day, permit, but it would have shown it for the inspections. And the point being, when this property was built and when the first floor was constructed, as it is today, it was permitted. There was nothing to show that, it was ever not in compliance. And I specifically asked of Ms. Mills, and I said, well, my client's charged under section 86-52. When was that enacted? She didn't know. So the point being, I think the evidence is that the house and the first floor were constructed prior to the enactment of 86-52. The use of the bottom floor, as my clients have it, should be permitted. Should the magistrate find that there are health safety issues, those can be cured. Meaning, you want a final permit for the air handler, fine. If you want the windows put in, fine. If you want an inspection of the electrical panel, fine. But the use of the first floor should remain the same. The evidence shows that it was built prior to the enactment of 86.52, and certainly the city didn't prove that this was in effect when the first floor was done. You've heard the testimony of my client who said she's never done the construction. They bought that as is from Wells Fargo. And even if you said that this was done by the Schaefers, that's during a period of time also because we haven't put the date for 86-52 of when that took effect. So the point being, we're now applying 86.52 to a use that was in effect prior to its enactment. As I say, if the magistrate finds that the health safety issues should be addressed, that's fine. But the use should be left alone. That was prior to my clients owning the property. That was way prior to Wells Fargo having the property. I think we can all assume and agree that Wells Fargo didn't make improvements. So it would either be by the Schaefers, but more likely by Mr. Pensa. And as I say, at the time, he was the building director for Pinellas County and certainly had, part of, for that period of time, approval of any building permits in the building. So, as I say, I think the evidence is that there's been no showing by the city that, in fact, 86.52 was in effect at the time that the first floor improvements were made. And I don't think there's any showing that my clients made any improvements. And certainly Wells Fargo didn't. So we're looking at either the Schaefers or Mr. Pensa. And since we don't have a date for the effective date for 86.52, I submit that the use of the property should remain as it is, that it is in fact grandfathered. And I would submit, ask permission to submit additional memorandum as to that. As to the health safety issues, raised by Mr. Trask and Mr. DeSantos, those can be corrected without changing the use. That's a matter of windows, the air handler, he wanted batteries for the smoke detectors and the electrical panel. And those can all be solved, within 30 days. But as far as, changing the use of the first floor, I submit that that certainly is grandfathered. Thank you.
Thank you, Mr. Conklin. Mr. Trask, will you address whether the use issue is before me? Because I'm not following if that is something.
The use is not before you, and the reason that it's not before you is because of the fact that we've removed that code section 110-177 from the violation notice.
Go ahead, Mr. Trask, with anything else?
I don't have anything else, thank you.
All right. The concern I have is that in the unrebutted testimony of Mr. DeSantis and in the video I saw, that there appear to be portions of the house that do not meet the Florida Building Code and never met the Florida Building Code, and specifically the ingress and egress from the bedrooms, the electrical panel, and the hot water heater. And I get the argument that this code provision may never have existed when the house was completed. I'm going to give the parties an opportunity, but a short window to provide a brief on that, but no more than 5 pages. I don't need, I just need the case law, local circuit court decisions, anything like that, administrative code, anything that would talk about the grandfathering in, and anything else that would say that once something is before me, that if it's a health safety issue, my hands are tied because it was built that way. I want to see the law on that if that's indeed what it is. And Mr. Trask, do you want me to just enter a ruling, or do we need to renotice a hearing for my ruling so I rule from the diocese here? What's the current state of the law on that?
Well, I don't think you do need to have another hearing. If you're going to request us to brief these couple of issues, we can brief those couple of issues and then submit them to you, and then you can consider them and make your ruling. I don't think that you're going to need to do it from the dais.
Okay. Do you agree with that, Mr. Conklin?
I see no reason why you should have.
Come on up. I want to make sure this is, I know your court reporter is getting it, but I want to make sure it's on the record.
If you're not permitting additional argument, I see no reason why you'd have to rule from, the bench here, that you can do it by a written ruling.
Okay. Is 14 days enough time for you, Mr. Conklin?
Yes, sir.
Is that enough time for you, Mr. Trask?
Absolutely.
All right. And like I said, no more than 5 pages, guys. I don't need extensive briefing on this issue. And
Since we have the same time period for submission, it's not to be with reference to the other sides.
no, just, you submit it whenever you want to submit it, but we'll do a cutoff at 5 PM, whatever 14 days is from now, assuming that doesn't fall on a holiday or a weekend, and just email them to my office. You just go look on the Florida Bar's website, and you'll have my email address, and you can just submit them there with a copy to the city clerk, so that you have something in the record for the city clerk as well. And then I will promptly issue a written ruling following submission of the briefs. Mr. Conklin, you understand what I'm saying today?
Yes, sir.
All right, Mr. Trask?
Yes.
All right. Anything else on this matter that council would like to present before I close the hearing?
No, sir.
No, sir.
Okay, thank you very much for your time.
Thank you.
That will conclude today's code enforcement hearings. Mr. Conklin, please make sure you provide to someone over here your notebook so that we
yes,
have it
I'm sorry.
in the record.